Hello, my name is Denita Jones, and I am a staff attorney at the Legal Aid Society of Palm Beach County in our Fair Housing Project.
Hi, my name is Jacob Beychok, and I am a staff attorney in the Legal Aid Society of Palm Beach County's Rapid Response Eviction Assistance Program.
We are here to share with you a brief overview of your rights as a tenant here in the state of Florida.
In the state of Florida, landlord-tenant law is governed by Chapter 83, Part 2 of the Florida statutes. There, you will find all you need to know about your rights as a tenant, the rights of your landlord, and the laws that define and regulate the relationship between you and your landlord.
Additionally, federal, state, and local fair housing laws apply to most landlord-tenant relationships. Under the federal and state of Florida's Fair Housing Act, housing providers are prohibited from discriminating on the basis of race, color, sex, religion, familial status, national origin, and disability. Palm Beach County also precludes housing providers from discriminating based on sexual orientation, age, marital status, or gender identity or expression. What that means is a landlord cannot refuse to rent to you. They cannot make housing unavailable. They cannot set different terms, conditions, or privileges for renting based on the aforementioned protected classes. Furthermore, if you have a service animal or emotional support animal, landlords cannot prohibit them regardless of their pet policy.
Before agreeing to rent any property, it is always wise to arrange a walkthrough of the property and identify and document problems that should be fixed before you sign a rental agreement. This is best done by taking photographs of any damages and providing the photographs to your landlord in case a dispute arises later. Be sure to keep in a safe place copies of any pictures and documents that you provide your landlord.
It is also important to read the proposed lease agreement in its entirety and make sure you understand all provisions of the agreement. Before signing the lease, you should be sure that it accurately reflects the rental amount you agreed to and that the date the lease commences and ends is properly stated. Additionally, be sure that the correct security deposit amount is stated on the lease and that the lease also reflects any advanced rent, such as the last month's rent, that is paid to the landlord. It may seem tempting to fast forward to the end of the agreement, so to speak, and sign the document without going through all of the fine print. But once you have signed the agreement, you are bound by its terms. Therefore, it is very important that you understand and know what your lease says.
Florida law does set forth certain responsibilities and rights that may not be waived in a rental agreement. It is important to know that you have rights as a renter and that your landlord has certain obligations to make sure your home is both safe and livable. Specifically, landlords are required to comply with applicable building, housing, and health codes and maintain the structural components and plumbing in good repair. Landlords are also obligated to install working smoke detectors and ensure windows have screens. Additionally, if you rent an apartment that has 3 or more units, your landlord must make reasonable provisions to exterminate pests and rodents, including rats, mice, ants, wood-destroying organisms, and bed bugs. Landlords are required to provide locks and keys, keep common areas clean and safe, provide trash disposal services, and provide functioning water and heating. Who pays for these services and how much they may cost should be included in your lease agreement. If the landlord must access your rental unit, then the landlord must provide notice 12 hours before they intend to enter and only enter at a reasonable time, which is typically between 7:30 a.m. and 8 p.m., except in situations where you have given consent or are unreasonably withholding consent or in case of an emergency.
Just as the landlord has responsibilities, you as a tenant also have responsibilities. As a tenant, you are required to keep your home clean and sanitary, remove garbage from your unit, not destroy, damage, or misuse the property in any way, refrain from removing anything from the house or apartment which does not belong to you, and conduct yourself and your guests in a way that does not unreasonably disturb your neighbors or cause a breach of the peace.
If your landlord alleges that you are not in compliance with Florida law or the lease agreement, they must notify you in writing of your noncompliance unless it is for failure to pay rent. If the issue can be corrected, you must be allowed 7 days to correct the issue before the eviction process may begin. In some instances, such as destruction, damage, or continued unreasonable disturbances, you may not have an opportunity to correct the issue and will have 7 days to surrender the premises. It is critical to note that a landlord may not evict you solely in retaliation for you complaining to a government agency about code violations or for asserting your rights as a tenant.
So, what do you do if your landlord does not comply with his duties and obligations under Florida's law? You should notify your landlord in writing by hand delivering or mailing a notice of non-compliance. You may then choose to terminate the rental agreement if your landlord fails to come into compliance within 7 days after delivery of the written notice or withhold rent. Remember, in any case, it is always important that proper notice is given.
There are a number of reasons why the landlord may seek possession of their property through a process called an eviction. These reasons include failure to pay rent, violation of lease terms, end of your written lease agreement, and if there is no written lease agreement, a termination of your tenancy. Florida's Landlord-Tenant Act clearly identifies the requirements for your landlord to file an eviction. For instance, in the event you have not paid your rent on time, your landlord must serve you a written notice allowing 3 days, excluding weekends and legal holidays, for you to pay the rent or vacate the premises. Otherwise, the landlord may begin the eviction process. If this occurs, the clerk of court will send you a written summons. Upon being served by hand delivery or posting the premises, you have 5 days, again excluding weekends and holidays, to file a response. If you receive your summons in the mail, you have 10 days to respond. Within 5 days, you must also deposit the amount alleged to be owed with the clerk in what is called the rent deposit registry. However, you may dispute the amount of rent alleged to be owed in your response with what is called a motion to determine rent. It is important to know that all of your responsive pleadings should be included in the same response, including your answer where you affirm or deny each allegation of the complaint, any affirmative defenses, any motion to dismiss, and the motion to determine rent.
If they apply, there are many affirmative defenses you may assert as a tenant in an eviction case against you. You may allege that your landlord did not give you proper notice, that your landlord did not give you the appropriate amount of time to pay rent or vacate, and that your landlord is demanding rent not yet due, that your landlord has accepted partial rent, or that you tried to or did in fact pay your landlord the total amount you owed. The plaintiff who filed the case against you must be the owner of the property, or if they are the property manager, must follow certain specific rules. The affirmative defenses are also where you would allege issues regarding maintenance, repairs, or the upkeep of the unit. In your reply to the complaint that your landlord filed, it is important to attach as much documentation as you can to back up your defenses.
If your landlord fails to do what the law or lease require, you may be able to withhold rent from your landlord. Again, you should deliver your landlord a written notice of the noncompliance and indicate your intention to vacate the property or withhold rent as a result. If your landlord does not comply within 7 days, you may withhold rent. Even if a dispute arises or an eviction is filed, your landlord is under no circumstances allowed to shut off your utilities, even if your landlord makes the payments on them. Change the locks to the unit, remove any outside doors, locks, or windows, or remove any of your personal property. You and your property may only be removed if the landlord goes through the court process and obtains a final judgment for possession of the unit, and you are served with what is called a writ of possession, which entitles the sheriff to return 24 hours after you receive the writ to remove you and your belongings. Otherwise, you may sue for damages or 3 months' rent, whichever is greater, plus court costs and attorney's fees.
If you decide to move, your lease governs notice requirements and other related requirements. If you do not have a written lease agreement and you wish to move, then you may end the rental agreement by giving written notice to your landlord of your intention to move. If your rent is due weekly, you must give 7 days' notice, or if you pay rent monthly, 15 days' notice. Deliver this notice in writing and also verbally communicate it to your landlord. Make sure you terminate your utility services and notify your landlord and post office of your address changes. Also, leave the property in a clean and sanitary condition, and even consider doing a walkthrough with your landlord before vacating. It is also a good idea to take pictures of the condition of the property upon vacating in case a legal dispute related to the property arises later.
Additionally, when you vacate the premises at the end of your lease, your landlord must return your security deposit within 15 days. Otherwise, within 30 days, they must give you written notice of how much of the deposit they are keeping and why. This must be done through certified mail to your last known mailing address. If this occurs, you have 15 days to object in writing, either through a complaint with the Florida Department of Agriculture and Consumer Services or by filing a lawsuit in court.
We hope you have found this video on your rights as a tenant informative. We encourage you to contact the Legal Aid Society of Palm Beach County for additional information or to apply if you are in need of services with regards to your tenancy.
We are available online at legalaidpbc.org and can be reached over the phone at 561-655-8944. Thank you.